Audible to everyone. Good evening. How are you? All well? Everyone is going to appear on 28th में. सबको देना है फ्री. हो गई पॉलिटी? नहीं, आप नहीं दे रहे? ओके. और भी कोई जो वेट करेंगे? So I hope that you people would have read polity at your own or at any institute or here anywhere, right? So in this series, what we are going to do, we will be covering entire polity, but through 50 questions every day, right? So we will be including some of the current affairs because I think that in polity everything is static. Even if what is there in current affair, that is static. Now there may be questions for parliament, right? There may be disqualification of Rahul Gandhi. नहीं करना चाहिए था, करना चाहिए था. Okay, that is another issue, right? So that is in the news. That is related to our syllabus, Representation of People's Act. But if you systematically cover the things in your class or in your notes or anywhere, so you would have been aware about all those things. So everything in polity, even be it from the current affairs, is static. So this is why I feel polity is one of the easiest subject. So you go to examination hall, outside the examination hall, you ask what is your favorite subject? Everyone is saying polity. But you ask after the examination, सबसे ज़्यादा गलती polity. Just because we are slightly negligent while reading and mostly negligent in the examination hall. Now this is my personal experience also. I will do some blunders which at home I might not do, right? Okay. So this is why I feel that in this series what we are going to do, we will be covering all the topics, all the units, specifically if there is in Lakshmikant, that's okay. If not, we will also be covering from here and there. Also, I will be mixing some previous year questions also, right? So that you will come to know that, yeah, on these kinds of topic, UPSC has gone into this much of depth, or UPSC is asking these kinds of questions. Few topics are very factual in nature, few topics are very philosophical, right? If I say there are philosophies in our constitution, do you agree? What are those? Equality, more than anything, more than your fundamental right, equality is a philosophy, it is a jurisprudence, right? For you, equality means different thing, for me, equality means different thing. For me, equality may be meaning similar payment with other teachers. For you, it may be meaning equality with your brothers and sisters, right? So equality has a different meaning for different people. So is liberty. So there are some philosophies in our constitution, and on those topics, UPSC will ask very analytical questions. We will see, right? But there are certain things like parliament. So India has two houses in the parliament, Lok Sabha and Rajya Sabha. That is a fact. We cannot change it. Why it is? Okay, that can be one issue. PMP material is sufficient for polity. Yes, for the static portion, it is sufficient. And for the current affairs, we have been doing current affairs here, so that I think will suffice. So PMP material I have personally made that. So I have included all of the Lakshmikant there, and also some other from like MP Jan or any other books, that is sufficiently included. This was a question from you too, not here. Okay, chalo. So let's start. So today what we are going to see is that we will be starting from historical background of the constitution, and mostly we will be covering fundamental rights, not today, fundamental rights maybe tomorrow, preamble and citizenship. These three things will be covered. One or two questions or 4 or 5 you may find from fundamental rights, right? Okay. So do you know what is state? What is your state? What is your state? India? Chak de India dekh liya kya? Nahi. So India is a state, that is true. So this is our first question, and why it is so you will have to answer that. Achha, this portion I have left it because here you can write your keys, any supplementary information you are getting you can utilize for writing this, right? Okay, so first question says, and of course this is a previous year question from 2021. So it says, which one of the following best defines the term state, right? Community of persons permanently occupying a definite territory independent of external control and possessing an organized government. Second, politically organized people of a definite territory possessing an authority to govern them, maintain law and order, protect their natural rights, and safeguard their means of sustenance. A number of persons who have been living in a definite territory for a very long time with their own culture, tradition, and government. Right? Society permanently living in a definite territory with a central authority, an executive responsible to central authority, and an independent judiciary. So these are the four options. Anyone with a possible answer? A. So most of the voices I can say is A. On YouTube also I am getting A. So one person has told B. I heard one voice. Those who are in favor may say A. Others no. पार्लियामेंट में ऐसी वोटिंग होती है, वॉइस वोट. ओके, चलो बी किसने बोला? हु टोल्ड बी? ओके, व्हाई? Political terms has been used, this is why. Okay, there are four basic essential element of a state. One is very important is sovereignty. Other three are population, territory, government, and fourth one is sovereignty. So sovereignty means, if I say that I am a sovereign person for taking my choices, internal as well as external, I am not supposed to take anyone's consent or anyone's permission. I can freely take my internal decisions and also I can freely take my external decisions. Now, if you go by the option B, you do not find the concept of sovereignty mentioned here. Sovereignty is missing here, right? This is the very simple. This is you will find in class 6 NCERT. जो civics वाली yellow color की किताबें आती है, this state definition is given there. The four essential element, right? So major thing is that all of the provinces, what we have the federating units like Bihar, Bengal, Odisha, Jharkhand, all of these we know in our nomenclature as states, but actually they are, rather we can call them a provinces or a federal units. They do not have the sovereignty. So this is why in terms of political science, they are not a full-fledged state. They do not have the complete sovereignty over there, right? So answer here shall be A, right? Answer here is A, because it is talking about a community of persons. So of course this fulfills the criteria. First, population, permanently occupying a definite territory. So second is also fulfilled. Third criteria, independent of external and control, sovereignty, and fourth one is there is organized government. So this first option fulfills all the requirements of being a state, right? Correct. This is a very easy question which was asked here in 2021. Okay. Now first unit of your Lakshmikant, in the very first act, right? Historical background. Okay, these are very boring topics, very factual. You have only one option: draw a mind map, draw a table. Whatever you do, you will have to mug up. There is no way out. There is no rocket science here, right? So with respect to British rule in India, consider the following statements about the Regulating Act of 1773. About the Regulating Act of 1773. The first statement says, the Act for the first time distinguished between the commercial and political functions of the company. Company here is British East India Company. It deprived the governor of Bombay and Madras of their legislative powers. It designated Governor of Bengal as the Governor General of Bengal and created an executive council for 4 members to assist him. Mostly I am seeing D. Okay. Anyone with the D, please. क्यों? 4 की जगह ये लॉजिक गलत हो गया. Okay. So third is the statement 3 is the correct statement, right? Statement 3 here is correct. So this is correct. Now about 1 and 2. The Act for the first time distinguished between the commercial and political functions of the company. It was Pitt's India Act of 1784. So this thing was done in the Pitt's India Act of 1784, right? And the second one, it deprived the governor of Bombay and Madras of their legislative powers. It did make them subordinate. So governor, earlier we were having the 3 presidency towns, Bombay, Madras and Calcutta, Bengal that is. So the governor of Bengal was made the Governor General of Bengal. So who was the person then? Warren Hastings. So if anyone asks you, UPSC will not ask definitely these kinds of questions. But on the road, if anyone asks you, first Governor General of Bengal, so he is Warren Hastings. But first Governor General of India, William Bentinck, right? So why? Because the complete centralization was done by the Act of 1833, and then the Governor General was Bentinck. So this deprivation of legislative powers of governors of Bombay and Madras was 1833. So first and second statement are false. Third one is correct. Our answer shall be B. Right? Through which of the following acts was a law member added to Executive Council of Governor General? Yes, please. Executive powers? It was about the legislative powers. That was 1833. B. Second was B. Third only is the correct. Legislative powers. Legislative power. Law making power. That was done in 1833 Act, not in the 1773. This thing was done in the Charter Act of 1833. We are talking about the Regulating Act of 1773. So completely legislative powers were taken away from the governors of Bombay and Madras in 1833. Right? Okay, so this is a false. Now, through which of the following act was a law member added to Executive Council of Governor General? 1833. On YouTube, any answer? Right? So this is B, unanimously B. You must be knowing about the Law Commission, first Law Commission of India by Lord Macaulay. So he is responsible for codification of criminal laws in India. The IPC, सिनेमा में सुनते हैं ना, दफा 302 के तहत फांसी की सजा मुकर्रर की जाती है. So that is from IPC, and IPC is codified way back in 1860. And the person behind codification of Indian Penal Code is Macaulay, is the chairman of First Law Commission of India. So since then, the law member was added, and this act was 1833, right? So our option is going to be again B. Shall we move ahead? कोई confusion? मैच द फॉलोइंग काइंड ऑफ अ क्वेश्चन. रेयरली अब यूपीएससी में आता है ना इस तरह के, बट ठीक है, कभी कभी यूपीएससी ऑल्सो आस्क एंटी एलिमिनेशन टेक्निक क्वेश्चन 1 और 2 ऐसा करके. अभी पूछा था ना, एलिमिनेशन वालों का भी तुक्का फेल हो गया वहाँ पे. So we have few provisions and the act corresponding. So we will need to match. Creation of Board of Control, Fits India Act. So this is 1784, right? C. Okay. Attempt to introduce system of open competition for selection of civil services. It is same. 1833. Establishment of Supreme Court at Calcutta. 1773. But this Supreme Court is not what Supreme Court we have today. Our present Supreme Court you can relate to the Federal Court that was established in 1935 Act, right? This Supreme Court was way inferior in the jurisdiction. This jurisdiction of this Supreme Court is even lesser than the High Courts, right? Okay. So this is local representation in the Indian Legislative Council. This is 1853. ठीक है, तो ऐसे करेंगे. विच विल बी द कोड? विल अगेन बी बी. बी फॉर बॉम्बे. In context of British rule in India, the Board of Control was abolished by. abolished by 1858. And if I ask created by, Pitt's India Act. So that system was called dual government. So one was board of control, another was court of directors. The two organizations were created within the British East India Company itself, right? So this was created by Pitt's India Act, but it was abolished by Government of India Act 1858. Since then, the whole administration passed into the hands of British Crown. So we had a new position called Secretary of State to India, right? And Viceroy. So Governor, erstwhile Governor General became the Viceroy. First Viceroy of India, Canning. So the answer here is D. Answer here is D. Acts बहुत परेशान कर रहे हैं. For acts, you can have a mind map created, and if not, we have done in the prelims master PMP batch. So usme in the handout you will find one thing, that in one page in the form of mind map or infographics we have summarized whole first chapter of Lakshmikant. So you will have to devise your own technique. Either you make tables or you make mind maps, anything, the short versions, or you can paste on your wall. You can rectify it daily. उसके अलावा और कुछ उपाय नहीं है इसका. There are so many acts. But one thing is that UPSC seldom asks the question from these acts, very rarely. It was asking before 2013 or before the change of the syllabus, factual questions like this from these units. But I rarely find questions like, if you compare previous 10 years question, from these acts you will find hardly one or two questions, That is not even 1%. But yes, I am not telling you to skip this chapter, because एक question भी आया और 2 नंबर का सवाल है. That is the difference between the people who will write mains and the people who will not write the mains. Right? Now question number 6. So consider the following statements about Charter Act of 1833. This act for the first time created Government of India having authority over entire territorial area possessed by the Britishers in India. This is the first. It deprived governors of Bombay and Madras of their legislative power. That came now. After this act, East India Company became the commercial, East India Company commercial role was ended and it became a purely administrative body. Right. So first is correct statement. Second is also correct, because just now we discussed. And third is also a correct statement. From 1833 onwards, company was not allowed to carry on any trade. Right. Before that, slowly and gradually, their trade monopoly were getting reduced. But after this, they were made completely a administrative organization. Right. Just to have the control over the territory they had occupied. They have annexed in India. So our answer going to be here is option D. Right. Option D. All of them are correct. Now 1858, about the Government of India Act 1858. It is also known as Act of Good Government in India. पता नहीं क्या गुड था, हम तो तब भी उन्हीं के कब्जे में थे, इसके बाद भी उन्हीं के कब्जे में थे. गुड क्या हो गया भाई, पता नहीं, सोचे होंगे. And there was they used to call it ना, civilizing us is a white man's burden. उसको सोच के बोला हुआ गुड करेंगे. So first is the act attempted to introduce a system of open competition for selection of civil servants, but it could not be done due to the opposition of court of directors. यहाँ पे 3-4 हिंट दिए हुए हैं. Court of director was abolished, right? It was already done, the introduction of open competition, right? Second is the act introduced the portfolio system in India. Portfolio system in India was introduced. What is portfolio system? One person, one ministry or two ministry, the allocations of various ministries to different person, and they will be in charge of them, like Ministry of Finance for one, Ministry of Education for one. Earlier it was used to be Ministry of Human Resource and Development, right? So From YouTube, anyone can answer question number 7. Question number 7 is D. D for, अच्छा ऑप्शन कहाँ दिखा आपको जो D? You people have handout, right? Okay. So we have to find not correct. First one is not correct. Second, the act introduced the portfolio system. It was done in 1861 Act. And the third says it changed the designation of Governor General of India to that of Viceroy. तो यहाँ पे देख के सब करेंगे ये सही है ना? एक ऑप्शन भी दिया होगा इसके लिए 3. But the half of it says who was to be the direct representative of East India's Company. He was to be the direct representative of British Crown, right? तो ये half देख के आंसर नहीं लगाने का, ठीक है? So all of these 3 statements are false, right? All of these 3 statements are false. Answer is D, this one. Now 8th number question, which of the following is not true about Indian Council Act 1909? What is the other name of this act? Morley-Minto reforms. So Morley was Secretary of State, Lord Minto the Viceroy, then Viceroy of India. After that also there will be another act in 1919, Montagu-Chelmsford reforms. So both again Secretary of State and Viceroy. First statement says it allowed for non-official majority in the Central Legislative Council. So what is false here is, okay, so 2 words, one is official majority and non-official majority. What do we mean by it? Official majority and non-official majority. Who are officials? Government. See, if I am organizing a congress here, मान लो congress. So I elect different people from old Rajendra Nagar, Karol Bagh, अलग अलग ब्लॉक से एक उठा के ले आए और लेवल अप में हमने लगा ली कांग्रेस, right? But there will be few persons who are representative of level up. So they will be called what? Official persons who are already under the employment of the person who is organizing that thing. So official members were those who were employed by the British, officers of the British government. Then we had other members who were nominated from outside, Indian members, native members, elected firstly indirectly, and then we will have gradually the introduction of direct elections, right? So it allowed official majority, but that at the provincial level. We are asking about central agency, Central Legislative Assembly. So this statement is false. It for the first time provided for the association of Indians with the Central Legislative Assemblies. Central Legislative Assembly, false. It was done way back, right? Raja of Banaras was added. Separate electorate for Sikhs, Indian Christians and Anglo-Indians were provided for the first time. So in 1999, that is famous for provision of separate electorate, but not for these communities. For the first time, it was provided for Muslims in India. The representation, separate electorate for Sikhs were given later, right? So it was done only for the Muslims. So this statement is also false. So फिर सही कौन है? All of them. Not true. You will have to find the not true. So all of them are not true. Our answer is D, right? About bicameralism in India. So bicameralism means 2 houses, 2 chamber of the legislative assembly or any legislative authority. Cameral means houses, bi means 2. Unicameralism means 1 single house, right? So India presently has bicameralism where at center. In the states, only 6 states has bicameralism. Rest others are unicameral. We only have the provision of legislative assembly in most of the states. In only 6 states we have legislative assembly as well as legislative council, right? So this is about the pre-independence thing. Bicameralism was introduced for the first time through the Government of India Act 1919. False or true? Second, bicameralism was introduced at the provincial level, where the provincial legislative council was replaced by the two houses. Those statements we have to consider. Firstly, bicameralism in India for the first time was introduced by 1919. This is a true statement. But which level at? At the central level or at the provincial level? At the central level. So if we know this, that it was introduced in 1990 at the Imperial Legislative Council, that is the central, then the second statement automatically becomes false, right? So what we have to find is, we have to find the incorrect statements. We have to find is incorrect statement. So our answer shall be B, because this is a false statement. Bicameralism at the Provincial Legislative Council was introduced in 1935, that too at very selective few of the states like Bengal, Bihar, United Province. In these 6 states, as of now, almost they are the states which are having bicameralism. Bengal में नहीं है, ठीक है. 1935 में हुआ था ये. So this first one is true, second one is false. Our answer is B, because we have to find incorrect, right? We have to find incorrect. Coming to question number 10. Consider the following statements about the Office of Secretary of State in India. About the Office of Secretary of State in India. Secretary of State, this office was created when? 1858 Act, right? So the office was established in 1858 and was vested with the complete authority and control over the Indian administration. So he was the representative, he was the person, secretary is what a kind of minister. So he was the minister of Crown there, who was responsible. He was residing in Britain only. But Viceroy, he was the direct representative of Crown, but he was residing in India, right? So this office was established in 1858 and his functions were to command authority over the Indian administration, right? Second is, the Secretary of State was also the chairman of the Council of India. This statement is true. The office of Secretary of State was abolished through the Government of India Act 1935. Right. So this office continued from 1858 till the time we got independence. And by which act we got independence? Independence of India Act 1947. So here this makes it false. It is rather Independence of India Act 1947. So this is false statement. Now see which of them are correct. Answer for the question number 10. Answer for the question number 10, C, right? It is correct, because he was the person over. If I say that your Minister of Railways is having complete authority over the Ministry of Railways, of course he will work under the command of the Prime Minister, because Prime Minister is the captain of that ship. That is true. That is true in other sense. So the Queen and King were having the complete authority over all the territories of the Crown then, right? But who is the person responsible for conducting those things? Is the Secretary of the State, right? Question number 11. During British rule in India, which of the following acts introduced dual system of government known as dual system of governance known as diarchy at provincial level? At diarchy दो बारी इंट्रोड्यूस करने की कोशिश की गई थी, तो भावनाओं में नहीं बहना है. You will have to look. It is talking about provincial level or central level. So we are talking about introduction of diarchy at provincial level. What do you mean by diarchy? Rule, di means two, archy rule, it denotes rule, right? Just say if I said monarchy, so it is the rule of a monarch, monarchy, oligarchy, rule of few people, right? Similarly, diarchy is the rule of two. Who were the two? One is governor, another is council of ministers who were elected. So this was the rule of two persons. Similarly, the subjects were divided into two parts. One is reserved and another was transferred. So the reserved subject were kept for the governor and his council, and the transferred for the legislature. So they will make the laws on the transferred subject, right? So this diarchy in the provinces was introduced at which, by which act? 1919. Now clearly let's see that diarchy at provinces was introduced in 1919. But if I ask, diarchy at the provinces was abolished 1935, फिर क्या आया वहां पे? So this diarchy at the central was introduced in 1935, but the diarchy at the provincial was abolished then, and provinces were given the autonomy. They were let free to form their own government the way we are doing it today. So various Congress formed the government at various states, but soon after there was declaration of civil disobedience, movement, independent satyagrahas and all, so they resigned, right? So answer for this question number 11 has to be, question number 11, let someone from YouTube also reply, they are a bit late. So answer is B. Consider the following statements about the office of High Commissioner for India. You know, if you travel from here and you go towards this Chanakyapuri, from Karol Bagh to Chanakyapuri, you will find the embassies of all the important countries. You will find embassies of United States, UK, Australia. What is difference between embassy and the High Commission? बोलिए Commonwealth. Okay. So actually, if there is a country A and there is a country B, both were being ruled by Britishers once, so they will be forming the part of the Commonwealth, and they appoint high commissioners to each other state, like you Australia, like Canada, like India. So these are all the part of the Commonwealth. So we appoint high commissioner, but other states like Russia was never under the British occupation, so they will appoint ambassadors. So this is, they all perform the same function, just the difference of nomenclature, right? So it is asking about, consider the following statements about the office of High Commissioner for India. The office was established in London by the Government of India Act 1858, right? This is true or false? This is true or false? Everyone agree it is a false? Then which act it established? This is false. This is false. But this was established in Government of India Act 1919. So this was established in Government of India Act 1919. Some of the functions of the Secretary of State was transferred to him. So the Secretary of State was formed in 1858. In 1919, they established a new office, and some of the functions were transferred to the High Commissioner, right? So second is true, but the creation of the office is 1919. So first one is false, second is true. Our answer is going to be B. During British rule in India, bicameralism was introduced at provincial level in some of the provinces. Just now we discussed open answered question. Government of India Act 1935. Government of India Act 1935. Right. So there are some 13-12 questions we discussed on that unit. Apart from that, if you further want to practice more questions on this unit, like historical background, you may be knowing about one book, Lakshmikant, but that is textbook. He also releases one book, Objective Polity. So that is having chapter-wise MCQ. You can go through that. That will have, I think, 10-12 और question मिल जाएंगे. Not to take too much pain for that. We just mug up the topics, mug up the act. Right, chalo. Question number 14 we have. So here our constitution things start. Achha, there is also another important topic of making of constitution. Like how we started to make our constitution. Cabinet mission plan came, they formulated one constituent assembly for us. Then people came, they sat together for 2 years, 11 months, 18 days, वैसे blah blah. तो वैसे करके उन्होंने संविधान बना दी हमारे लिए. So that was not done by the single person. Usually what we say, Dr. Ambedkar wrote the constitution for us. Now that is partially true because he was the key prominent person behind writing of the constitution because he was heading the whole drafting committee. But there was various other committees also. The work of the drafting committee was to prepare a rough sketch of Indian constitution so that could be tabled before the Constituent Assembly. Those provisions may be discussed. If someone wanted, they could be amended, right? So the drafting committee was responsible for preparing the draft. In addition to that, there were various other committees also, committee for negotiation with the states, so on and so forth. So that is also another unit which is given in your book. Apart from that, you should be knowing because I would think that rather than asking questions from these historical backgrounds, UPSC may ask questions from those committees. That is still more relevant for our constitution. Not to worry, we will cover maybe in the next class, we will also cover the questions from those committees or making of constitution, right? Okay. So the first 14th number question is, which one of the following objectives is not embodied in the preamble to the Constitution of India? UPSC asked this question in prelims 2017. Your options are liberty of thought, economic liberty, liberty of expression, liberty of belief. So our preamble starts with the nature that we will make India a sovereign, socialist, secular, democratic and republic country. Then we have certain goals, right? Liberty, equality, justice. So we talk of justice of how many kinds? 3 kinds. Justice, social, economic and political. How is political justice ensured in India? Which provisions of our constitution ensures political justice? Fundamental rights, right? How? What do you mean by political justice? That is a kind of political justice, but that is the exact apt definition of constitutionalism. Restriction put upon the state, right? Political justice means that while electing the government for you, you are treated equally. That I am the same suffrage, I am having the same suffrage as you, as he or she. That is one kind of political justice. Secondly, political justice also includes certain civil rights. Civil rights are anti-discriminatory rights. So those fundamental rights and also the Article 326 of our Indian Constitution that prescribes for right to vote, universal adult suffrage. So that ensures the political justice in India. Socio-economic justice, if I talk about, directive principles of state policy. But the major flaw there is that is non-enforceable by the courts. However, they have been enforced by various acts. If I say there are provisions like nutrition, so you have Poshan Abhiyan for that, National Nutrition Mission. If you talk about maternity benefit, you have Maternity Benefit Act, right? So the Parliament has tried to enforce DPSP by various ways, but fundamental rights are self-executory. They are enforceable. They are justiciable in nature, and they ensure political justice. Coming back here, that we have 4 kinds of liberty. Liberty of thought, expression, belief, faith and worship. 5, right? What kind of liberty we do not have is economic liberty. So preamble does not embody economic liberty. Our answer is going to be 14B. Yes, right, 14B. The minds of the makers of the Constitution of India is reflected in which one of the following? Preamble, unanimous, right? So this was actually, you will find in your book again the same line, but this is the statement of the Supreme Court in the very famous Berubari Union case. So in Berubari Union case, Supreme Court, while interpreting the suitability, or you can say the utility of the preamble of India, Supreme Court told that yes, this is important. You can interpret what constitution makers were thinking while they were writing the constitution, but apart from it, it has no legal implications. You cannot get it enforced by courts, right? So the minds of the constitution makers is reflected by preamble. Which of the following is or are the characteristics of a republic? India is a republic or democracy? Both. We are a democratic republic. Can you give me an example of any country which is a democracy but not republic? How? So in republic there is no concept of monarchy. Why? First option says the head of the state is always elected, maybe directly like United States or indirectly like us. So we are also republic, US is also a republic. They have the head of the state, president, they are directly elected. We also have the president who is indirectly elected. So head of the state has to be elected, whatsoever means may be directly or indirectly. This also means that there is no hereditary position reserved. If you again compare United Kingdom with us, the major difference is that they have a position of crown, king or queen, which is hereditary. Elizabeth gayi, so king aa gaye. But that is related to the same family. No other person can occupy that post outside of that family. Meaning the head of the state is their hereditary thing. Second, political sovereignty is vested in people, because we are electing our head of the state, right? All public offices are open to every citizen without any discrimination. And this is the beauty. People from the lowest strata of the society can come compete with the people getting very good quality education, be on the same ranks as the affluent sections of the society. They can also become the president. Abdul Kalam, he used to sell newspapers in Rameshwaram and then went on to become the president of India. This can happen only in republic, not in England, because they have a hereditary, right? So first is head of the state is always elected, political sovereignty is vested in people, all public offices are open to every citizen without the discrimination. Our answer is going to be for 16. For 16 our answer is D. All of these are political sovereignty is vested in people. See, if I say sovereignty means the capacity to take decision, right? If I am occupying the topmost post and I cannot be changed, suppose for example Hitler was sovereign during his time and he could not be changed. He had reserved that seat for himself. Now again, if you can again correlate with United Kingdom, who is sovereign? Of course, nominal sovereign, crown, they cannot be replaced. People are not the sovereign there. But in India, people will elect certain persons who will be acting as the sovereign for that particular fixed period of time. So ultimate sovereignty is lying with whom? People of India. Popular sovereignty is lying with people of India, right? Yes. It is a part, you can say it is a feature. In democracy, you will elect a government that may be sovereign, that may not be sovereign. Government may be sovereign, government may not be sovereign at times, right? But here you are electing a sovereign who is not a permanent, right? Question number 17. Which one of the following reflects the most appropriate relationship between law and liberty? आई थिंक दिस मे बी इवन 2019 और 2018 का, मेरे को इसका थोड़ा उतना क्लैरिटी नहीं है, बट दिस इज आस्क्ड इन प्रीवियस ईयर्स, राइट. If there are more laws, there is less liberty. If there are more laws, there is less liberty. It can be, because law is what? A means of social control. If there is no law, there is no liberty. Why and how? Agree to this statement. That is it a true statement? If there is no law, then there is no liberty. Can anyone explain it? How? Yes. So, more powerful persons will discriminate or exploit the less powerful persons. Because if there is law, everyone's personal liberty is limited. See, suppose that if I say everyone is independent to do whatever you wish to, there may be a person who is weaker, there may be a person who is stronger. So the stronger person may suppress the weaker persons. So in that situation, their liberty will be curtailed. So time and again there will be exploitation like this. A time will come, there will be only one person who is having liberty, rest other will not have any liberty. So law is to keep a check that so but everyone can enjoy a bit of liberty. If you leave anyone without the law, that will be the state of anarchy, lawlessness. So here the most appropriate out of is that if there are no laws, there is no liberty. Rest others, sometimes they may be true, sometimes they may be not. We have to choose the most appropriate out of the four options, and this is going to be B. 17B. (18) Democracy's superior virtues lies in the fact that it calls into activity. Why? See, people have called it that democracy is the second best form of government, because best is yet to be discovered. Right? So best available form of government is democracy. But why it has been called to be the second best or best? Why it is very good form of government? At times we say, वो मूवी देखा है क्या अभी पॉपुलर हुआ था वो साउथ वाला कन्नड़ा रॉकी भाई वाला, कौन सी मूवी है? KGF. उसमें आता है बोलता है ना, किसको चाहिए डेमोक्रेसी मैडम? प्राइम मिनिस्टर के ऑफिस में घुस के धमकी देता है. तो डेमोक्रेसी हमें चाहिए, वी नीड डेमोक्रेसी. क्यों? बिकॉज इट इज अ गुड फॉर्म ऑफ गवर्नमेंट, इट विल इंश्योर गुड गवर्नमेंट. बट वाई इज इट सो? So first is the intelligence and the character of ordinary men and women. Second, the methods for strengthening executive leadership. A superior individual with dynamism and vision. A band of dedicated party workers. इसको तो पहले हटा. ठीक है? A superior individual with dynamism and vision may lead to someday Hitler next. It may create a dictatorship. So it is kind of two-edged sword. Like the present government is being accused of behaving in a dictatorial manner because the whole thing is revolving around one person, right? So this we also exclude. The method of strengthening executive leadership, for a moment we can consider it if there is a presidential form of government specifically, but not democracy as a whole. Why democracy is good? Because it asks we, the people of India, to exercise their voting right and choose the person who are going to govern us. It calls our wisdom that we, okay, you want to rule us, we will be electing you because I think that you are capable enough. हाँ, ये अलग बात है, बीच में पैसे वैसे मिलते हैं. ठीक है, in local self government elections you find too much money into it. So people will keep a fund, okay, 2 crore, I will become councillor and I will earn 4 crore. So in 5 years money is getting doubled. It can. So this is 18. Answer is A. Answer is A. This democracy is option A. See, out of these 4 options, 3 we eliminated. Now we are talking about the democracy is good form of government. Why? Because it is testing, it is calling, it is asking the mandate of the people every 5 years. People are electing themselves. They are electing the persons who are going to rule them. Can you find any other better alternative than this? Can you think of in the present context? Can you think of a monarchy? Monarchy is not taking the choice of the people. Can you think about oligarchy, where few groups of people will be ruling? Can you think of a China-like country where a person declares that now I will be president for lifetime? Because there is no consent of people involved. In democracy, it is the rule of the people, by the people, and of course, if these two things are fulfilled, it should be for the people, right? Because it is revolving around the person who is getting ruled. It is the consent of us. Of course, we have the multiple factors. One person may be very popular, that the whole elections are getting center state for him, but that is a different thing. That is, you can say, negative aspect of not having a good and a strong opposition. But still, even if that person or any other person is getting victory over elections year after year, that is also after the mandate of the people. So mandate of the people is important, and people give mandate after exercising their wisdom. You must have heard about it that under the Representation of People's Act, there is a mandatory provision to disclose their income. Why it is so? Because once a candidate comes in to file the nomination, you are aware about his educational qualifications, you are aware about his or her income, that what is his present income. After 5 years, you can ask that okay, 5 साल में कितनी कमाई हुई आपकी, सैलरी तो इतनी ही थी. So whether you did certain corrupt activities, so all these things can be analyzed by the people, and then they will be able to take the choices. So this is why democracy is found to be more suitable than any other existing form of government. Right? There are flaws in the democracy. At times it is very slow in decision making, especially if you talk about the parliamentary democracies, because you will have to pass, if there is 2 houses, from one house, second house, then you need the consent of the executive head, that is the president. In presidential form of government, Trump will take decisions like this, then he will go to jail. Okay, so answer here is A. 19 number question, which of the following forms of justice is encompassed in the preamble to the Indian Constitution? Social, economic and political. Very easy question. Consider the following statements about the bill referred by the President to the state legislature under Article 3. Article 3 talks about reorganization of state. Article 3 talks about reorganization of state. What are the ways and means through which state can be reorganized? Or that is majority. Like if you talk about state reorganization, what do you mean by it? Okay, we can bifurcate one state into 2. We can change the names. We can merge 2 states. Right? So all these things are under the scope of Article 3. Right? So first statement says the state legislature must express its views within 14 days. Is there any such kind of limitation? So what is ideal process? Suppose that if Andhra Pradesh is to be bifurcated into Andhra and Telangana, it is the sole prerogative and power of union, that is parliament. State government, state legislature may be simply asked. So if firstly the rule says, Article 3 says that any state reorganization is to be done, a bill will be presented in the parliament. That bill should be presented with the prior recommendation of the president. After that president's recommendation is sought by the legislature, there will be voting. Voting requires only simple majority from both the houses. Simple meaning 50% of present and voting. So it is as simple as passing a law. Parliament being in Delhi can change the political map of India, redraw the political map, internal political map of India. Right? In the meanwhile, this consent of the state may be taken. That what do you think? Now if the state says no, please do not divide me. So is parliament bound by that? No. There have been instances when Bihar was to be divided into Bihar and Jharkhand. The Assembly of Bihar resolved against it, but still Bihar was bifurcated because the resolution of the state is immaterial for Article 3. Parliament is not bound by the advice of the state legislature here, right? So there is no limitation of time also. First statement is false. Second says in case of union territories, there is no requirement of referring the bill to the concerned legislature. For that matter, we have only 2 union territories which are having state legislature. बाकी में तो है ही नहीं. Jammu Kashmir 3 now, but earlier as well it was 2, Delhi and Pondicherry. So union territories are directly under the command of the union. At some places, because the population is big, what happens? Why you would think that Delhi got this state legislature? Because if you exclude Delhi, you will exclude crores of people from getting represented at various states. Because if the union territory having no state legislature, there will be no representation in the Rajya Sabha, right? There will be no representation in the no representation in the president election. So you will exclude the election of president. 3 करोड़ लोग भारत के president को elect ही नहीं करेंगे. ठीक है. So because they are also the part of India, they are also the citizens. और ये बहुत amount में है. For other union territory, either they are less, they are scattered from here and there. So because of those reasons, we could not afford to have a legislative assembly there. Because giving legislative assembly means you are forming a popular government. And if union territory is under the direct control of union, a popular government in the union territory may lead to clash. इस वजह से हम सारे यूनियन टेरिटरी को लेजिस्लेचर दे भी नहीं सकते और बहुत बड़े यूनियन टेरिटरी से लेजिस्लेचर हटा भी नहीं सकते. So this is why 2 union territories only, now 3 have got legislative assembly, right? Okay. So in case of union territory, there is no requirement of referring the bill to the concerned legislature, right? This is true or false? This statement is true. First statement is false. We need to filter out the correct option. Correct is 2 only. Question number 21. Consider the following statements about the commission committees formed after the independence to examine the feasibility of reorganization of states on linguistic basis. Before answering, please read all the options very carefully because answer lies in the options only. First is saying Dhar Commission and JVP committees were formed by Government of India to look into the issue. Why false? Yes, JVP was a committee which was not formed by the Government of India. It was formed by the Congress. So JVP means Jawaharlal Nehru, Vallabhbhai Patel and Pattabhi Sitaramaiah, who was then the president of Congress. Right? JVP committee was headed by Pandit Jawaharlal Nehru. Both Dhar Commission and JVP committee rejected the idea of reorganization of state on the grounds of language. True. First is false. We are confused in the second. JVP committee had no president or convener. ये लिखा हुआ है, आप लक्ष्मीकांत पढ़ना, उसके फुटनोट पेज में लास्ट में देता है ना चैप्टर के, वहाँ पे लिखा हुआ है This committee was left without any chairman or president. इसलिए मैंने बोला थोड़ा ध्यान से पढ़ने का ऑप्शन, right? So this is also a false statement. 3 is only correct, right? (22) The state of Telangana was formed by the Andhra Reorganization Act 2014. Consider the following statements about it, right? First is, the act was passed as per Article 2 of the Constitution. According to Article 4 of the Constitution, the laws made under Article 2 and 3 of the Constitution are not to be considered as an amendment for the Constitution. These are the 2 statements, right? First is false, you are saying. Why? because Article 2 is about admission of new states, and this was reorganization of already existing state. So Andhra was bifurcated under Article 3 of the Constitution, not the 2 of the Constitution, right? And it is a true fact that it is written in Article 4 that any state reorganization act which is passed under Article 2 or 3 will not be considered as an amendment to the Constitution. Why? Because it is passed with simple majority. Article 368 contains provision of amending the Constitution with 2/3 of present and voting, bas, plus absolute majority. So two requirements are there. To pass any constitutional amendment under Article 368, Parliament needs 2/3 of present and voting, but that 2/3 number secured shall be more than the absolute majority. That is 50% of the total membership of the house से ज़्यादा होना चाहिए, right? Let's take an example. Suppose that there has to be a bill which has to be passed by the way of amendment, and it is introduced under Article 368. Now it is put to vote in the Lok Sabha having the total strength of 543. Anglo-Indians are no more represented, right? So 543 is the total strength. What is the absolute majority? 272, जिस पे सरकार बनती है. This is the absolute majority. Now on the given day, I say 390 members were present and all were voting. Nobody abstained from voting, right? So out of this 390 members, 2/3 voted in favor. So how many? It is 260. Now you tell, can the amendment be passed? No, because though it got the 2/3 of the majority, it could not pass another requirement, that is absolute majority. They will at least need 272 in the Lok Sabha and uske extra 2/3 of the present and voting. These are the two criteria which needs to be fulfilled for passing an amendment. And amendments में joint sitting नहीं होती. It needs to be passed from both the houses separately, right? Okay. So coming back to this question, the first is false, the second is true. We are to find the correct. Our answer is B. Our answer is B for question number 22. Arrange the following orders in the chronology. So there may be 2-3 sources to read these kinds of questions. One is that you have one NCERT. Which one? Politics in India since independence. Now I am not telling to read because there are hardly 40-45 days in your examination. But that is one book where you will find the journey of India after we got independence till 2000 or something. That has various issues like reorganization of the state. That is the first chapter. Then dominance of Congress party. Then the era of coalitions. Then you have social movements, all those kinds of things. So there also you can find the answer to these kinds of questions. There was a question, I think in 2017 they asked one chronology. When was bank nationalization done? Communist party का formation, ऐसा कुछ करके उन्होंने question पूछा था, right? This also you can find in your Lakshmikant. There in the first article 1 to 4 वाला जो chapter है, union and its territory. In the last segment you will find that which state got statehood when, right? So if you have to arrange this in chronological order, you can say Gujarat in 1960, Gujarat in 1960, then Nagaland when 1963, अच्छी बात है, याद है सबको. Then Manipur 1971 to 1972, and this Haryana 1966. So Punjab and Haryana were bifurcated. Union territory of Chandigarh was carved out because दोनों को चाहिए था चंडीगढ़, तो उसको कॉमन कैपिटल बना दिया. So this is 1966. So we have 1243 A is the correct answer, right? Consider the following statements about inner line permit requirements in India. Inner line permit requirements in India with respect to Arunachal, Nagaland and Mizoram. Inner line permit is that though you have the freedom of movement, you can travel across the territory of India. भारत में कहीं भी आप घूम सकते हैं, but there is a restriction in some areas. You require the prior permission due to those areas disturbed, protection of the interest of scheduled tribes, right? तो यहाँ पे इन 3 states में you will require inner line permit. This question is about that. Manipur is also there, but it is in this question we have asking about only 3. It is required by both foreigners and Indian citizens from other states. Why not foreigners? Visa लेके आएंगे ना. This is a kind of a visa for our own citizens. ठीक है? It is provided by the government of the state you are visiting. The concerned state government has the power to issue the inner line permit. First, there is this foreigners will require visa. ILP से उनका काम नहीं चलेगा. ILP is usually granted for first 15 days. It can be extended. 15 days के लिए generally दी जाती है, but it can be extended if the person is working there or if any local resident is sponsoring the person, so it can be extended, right? Okay. So, but firstly they will require visa, and in visa they will have to disclose that where they are going. If you apply for visa, you disclose your purpose, right? Inner line permit. No, inner line permit is only for our own domestic citizen. They have this protected area permit, PRAP. Foreigners will require another documents. That is coming in the question. What are you saying? That both by foreigners and Indian citizens from other states. Only for whom? You are telling that in the question it is saying कि only inner line permit is required by foreigners. But foreigners, why will they need inner line permit? Foreigners, they will firstly disclose in the visa, na? Okay, chalo. So I'll check it once again that it is framed from an Indian Express article. I'll revisit the article and then we'll discuss that in the next class. Okay, still I think that for foreigners, specifics to Indian citizens, Indian inner line permit, foreigners do not require inner line permit. That is वो आगे आ रहा है, that is a restricted area permit. There is this. Restricted area permit and protected area permit. These are required by the foreigners also. Right? Inner line permit is only for the domestic Indian citizens. Right? Okay. So first is we are taking it as false. Yes, please. Nahi. Border area. You may require another kind of registration. But that is not under this citizenship. It is for protection of forest, right? All those their mining is too much, sand mining. तो उन सब वजह से वहाँ restriction किया जा सकता है आपके movement को. Your movement can be restricted on the public interest or for the protection of interest of scheduled tribes. So in the public interest, your movement can be restricted anywhere. For that matter, you can take an example. There was a very famous case where the movement of prostitutes were restricted in the nearby highways. उनका भी वो fundamental rights था. But in the interest of public, that was restricted. So in Uttarakhand, it may be restricted. This has a better connotation with the citizenship status. We are asking कि हम अपने citizens को in a general, we are asking them to go for inner line permit because of the areas bit disturbed and people from outside settling into there, bringing refugee crisis. Those areas has been witnessing these kinds of problems. This is why this is arrangement कि आप inner line permit लेके जाओ, you will temporarily go. There is a restriction on purchasing the land also. A land allocated to tribal cannot be sent to sold to a non-tribal person. These are regulated by you under Schedule 6. ठीक है. उत्तराखंड में you will find the restrictions on other grounds, not on the inner line permits. Right. With reference to India, consider the following statements. There is only one citizenship and one domicile. A citizen by birth only can become the head of the state. A foreigner once granted citizenship cannot be deprived of it under any circumstances. One says there is only concept of one citizenship, single citizenship and one domicile. किसी के मन में कंफ्यूजन है कि दो डोमिसाइल है मेरा? हाँ, मैं महाराष्ट्र से हूँ, दिल्ली में आके तैयारी कर रहा हूँ, तो मैं दोनों जगह का डोमिसाइल हो गया. डोमिसाइल, टू डोमिसाइल इन इंडिया, कैसे एक्सप्लेन करिए. कैसे कैसे, वही तो मैं पूछ रहा हूँ. गिव मी एन एग्जांपल. वो गलत है, उसको कैंसिल कराओ और ऐसे पब्लिकली ना बोलो. एक को आप कैंसिल करिए, ठीक है. देयर इज ओनली वन सिटीजनशिप एंड वन डोमिसाइल, राइट. A citizen of by birth only can become the head of the state. Any citizen, naturalized or son of soil. So the citizen by birth are called son of soil. So they can become. So this is a false statement. A foreigner once granted citizenship cannot be deprived of it under any circumstances. There are various grounds. Like अभी राहुल जी को 2 साल की सजा हुई. If any person within 5 years of acquiring the citizenship of India sentenced to jail in foreign country for more than 2 years, तो उनकी citizenship छीनी जा सकती है. There are various other grounds. If any foreigner has acquired the citizenship of India by deceit, fraud, it is liable to be taken away by them, from them, right? So this is also a false statement. Our answer is A, one only is correct, right? This is a Manipur People's Protection Bill 2018, the recent thing. It is aimed at regulating the migration of all non-Manipuris in the state. Second, under the bill, the definition of Manipur people includes Meiteis, Bengal Muslims, scheduled tribes listed under the constitution of the Manipur. Okay. Any answer? Current affairs का ये. It is firstly, it is aimed at regulating migration of all non-Manipuri people into the state. We are talking about na inner line permit Manipur में लेंगे. So this is this. The people coming outside from the Manipur, people coming from outside of the Manipur, they are regulated under this bill of 2018. First is the true statement. But what is the catch here is about the definition of people who are non-Manipuris. इसके definition में क्या है? हाँ? People who have been living before 1951 in Manipur, they are also called Manipuris. This point is not mentioned in this definition. इस criteria में ये बाकी सारे criteria होते हैं. Since it is mentioned here only, अगर यहाँ पे only नहीं लिखा होता, it would have been a correct, or we would have included about the people who are settled in Manipur before 1951. So this statement will be true. They are also called Manipuris. They will not be termed as non-Manipuri people, right? So first is true, second is false. Oh, sorry. देखा? We have to find incorrect, right? Consider the following statements about protected area permit and restricted area permit, right? it can be issued by the Ministry of Home Affairs. Citizens of Pakistan and China cannot be given any of these permits. PAP comes under the this order. PAP comes under Foreign Protected Areas Order 1950 and RAP comes under Foreign Restricted Areas Order 1963. थोड़ा factual है, again from few newspaper articles. What is the answer? First statement correct है या false है? It can only be issued by the Ministry of Home Affairs. अच्छा, ये only डाल के मैं तुक्का मारना नहीं सिखा रहा हूँ, मैं फैक्ट बता रहा हूँ. It can be issued, the power to issue this PRAP and RAP is delegated to other authorities also. This is not only to the Ministry of Home Affairs. For some category of people, the prior permission of the Ministry of Home Affairs is required. Other, it can be automatically issued by the authority which has been given the power, like local authorities, state authorities. Right? For the citizens of Pakistan, China, they can be given this permission. But before giving this permission, the consent permission of Ministry of Home Affairs is required. For others, it can be given automatically. ठीक है, पहला इस वजह से false हो गया, ये इस वजह से false हुआ. It can be given, but with the prior approval of the Ministry of Home Affairs. Third one is true. Our answer is B. We can give prior permission. Yes, please. No, ILP. Which law? Yes, I think I am just suspicious about it, but it is coming from that one. These two, there are various orders which has been released by the ministry. These are the two orders. Order is different from law. Law necessarily is passed by the parliament. Order is released by the executive. Right? Law means that it has been passed by either parliament or the state legislature. But here these are the orders. Orders have the same validity for part 3 or part 4 of our Indian Constitution. For fundamental right in DPSP, both law, order, bylaws, ordinance, everything is same. But the essential difference is that order will be passed by the executive persons, like ministries. Right? So these PAP and RAP is derived out of these two things. Right? You can read more about it if you want to. Ministry of Home Affairs पे FAQ पढ़ा हुआ है, frequently asked questions. तो उसमें से जो important है that we have covered, right? कहाँ पे थे हम? 28 ना? So about the citizenship, various provisions of the citizenship. Article 5 to which article talks about the citizenship? 5 to 11 of the Indian Constitution. What is in Article 5? Article 5 talks about the persons, Article 5 talks about grant of the citizenship to the person who were domiciled in India at the time of commencement of the Constitution. So A, यहाँ पे आ जाएगा D, right? Now Article 6. Article 6 talks about a person who migrated to India from Pakistan. See, when India got independence, our country was divided into two portions, India, Pakistan. So there were some persons who were willing to go to Pakistan, live there. There were some persons who were willing to come to India from Pakistan and settle here. There were another category of person who initially went away and then came back. उधर का माहौल अच्छा नहीं है, ठीक है? हाँ. So that is Article 7. राइट। तो फर्स्ट का फर्स्ट छोटा नहीं हो सकता, आर्टिकल 5 ये, आर्टिकल 6 अ पर्सन, आर्टिकल 6 is talking about person who migrated to India. Article 7 is talking about person who migrated from Pakistan to India, right? अब इस वजह से आपका आंसर क्या होगा, जो बचा है वो 4 का हो जाएगा। आंसर इज सी, राइट, आंसर इज सी है। We will do till 30. We thought we will finish till 50 because you have a pending class after this. Which one of the following may be considered illegal migrants under the Citizenship Act of 1955? Illegal migrants. There is, if you talk about the acquisition of citizenship of India, person those who are illegal migrants cannot be given, neither by birth nor by descent nor by naturalization. Illegal migrants को हम citizenship नहीं देते. Who are those persons who are called illegal migrant? The person who enters India without passport or travel, one who stays in India beyond the permitted time. 2 महीने की पास वीजा लेके आ गए, भूल गए, इंडिया में तो कोई देखता ही नहीं है, इतनी पॉपुलेशन है, कहाँ पुलिस स्टेशन में रजिस्टर कराने जाते हैं, अभी ढूंढोगे तो निकलेंगे 50-60 लाख। तो बोथ इधर अ पर्सन हु एंटर्स इंडिया विदाउट अ वैलिड पासपोर्ट और ट्रैवल डॉक्यूमेंट, कुछ कंट्री से हम पासपोर्ट के बिना भी ले लेते हैं, जैसे अबाउट नेपाल, पीपल कमिंग फ्रॉम नेपाल टू इंडिया दे डू नॉट रिक्वायर पासपोर्ट। मेरे नानी का घर नेपाल में, तो हम बचपन में घूम के आते थे, इट इज काइंड ऑफ दैट, राइट। सो बोथ 1 and 2 they will be called illegal migrant, right? A legislation which covers which confers upon the executive administrative authority in an unguided and uncontrolled discretionary power in the matter of application of law violate which of the following articles of the Constitution? Which concept is applied here? Equality before law and equal protection of law, that is mentioned under Article 14. But if I give executive uncontrolled power, rule of law violate होगा, because rule of law is imbibed in under Article 14 of the Indian Constitution, and there are 3 main principles of rule of law. First one is absence of arbitrary power in the hand of any 1 person, 2 person, 3 person. Wherever there is a presence of arbitrary powers, if you give me arbitrary power, I may act as per my whims and fancies. I may take no class from today onwards, prepare on your own. So this is arbitrary. I will not say like that, right? Because I want everyone to be here, pass the examination. सारे बच्चे हमारे इंस्टीट्यूट के हों, ठीक है? तो if you give arbitrary powers, they will consider themselves above law, superior to law, and the basic concept of rule of law is everybody is equal before law, right? So if any arbitrary, unthought, unguided, uncontrolled power given to the executive will be violation of Article 14, will be violation of rule of law, and rule of law is imbibed under Article 14 of the Constitution, right? So we shall pause it for today, right? There were 20 more questions to be discussed, but कर लेंगे. We are planning to cover 500 questions in polity, and apart from that, other subjects also, like Monday, Tuesday, Wednesday, modern history, ऐसा करके you'll get the detailed idea. So we will be covering almost all the subjects, right? अच्छा, people who had joined on YouTube, you can download the Telegram. वहाँ पे जो हमारे चैनल है वहाँ पे इसके PDFs हैं. So now and before coming to the next classes, you will find the PDF handout which are given to our offline students. You will find in Telegram. Any doubts so far? Any questions to be asked? You need amendment for cessation of territory. Yes, for that you need. Acquisition के लिए नहीं जरूरत पड़ती है. For cession of Indian territory to any other foreign country, you will need amendment, but that is not applicable to settlement of land boundary agreements. Simply एक boundary dispute settle करना है, उसके लिए you will not require the amendment. But cession of Indian territory to any foreign country, you will require the constitutional amendment. Acquisition के लिए हम हमेशा तैयार हैं.